Your Honors, in the U.S. Sugar versus Henson case, the Florida Supreme Court announced that in the vast majority of cases, a Frye inquiry will not be required. And in fact, in Castillo, the gadgets used, again, the scientific evidence used, was animal studies, in vitro tests, clinical epidemiological studies, and genetic tests. These are the things which evoked the aura of credibility that the opinions of the experts based their conclusions upon. And in fact, the appellees in this case are in fact objecting not to the methodology, they are objecting to the conclusion of the expert, which we know from both Henson and from Castillo is not appropriate.
So your argument is that the facts aren't subject to Frye and the conclusion isn't, only the methodology.
That is the law in Florida.
So if they completely skip the methodology, they never do any test at all, just say, well, I looked at you and I can tell from looking at you that you've got fibromyalgia because I'm a trained clinician. I can tell that you've got it and it was caused by that auto accident. That evidence would come before the jury based upon it being pure opinion. And your argument would then be, it would be the defense's obligation to show that there was no methodology, no testing, no nothing. They just looked at you.
That is precisely correct, Your Honor. And the defense's experts would also expose such a specious opinion if an expert were to render such a specious opinion. And so...
How does that... You made a public policy argument earlier, but isn't it part of the trial judge's job to make certain that he or she serve as a gatekeeper and make certain that only evidence that's at least within the realm of reality can come before the jury? I mean, if you're telling me that in your world, the expert ought to be able to come in and do no testing at all and simply say, I'm an expert, I know what fibromyalgia looks like, you got it, and it was caused by the accident. And leave it up to them now to come in and cross-examine on the lack of any testing or the lack of any scientific evidence. What public policy is enhanced by a rule that would allow that sort of unsubstantiated testimony to come before a jury?
Your Honor, I'm not sure that that's a correct statement of what it is, but all I can tell you with what the law is and what appears to be the public policy reason behind Frye.
But in your world, your argument is you believe the law of Florida would allow the testimony that I just outlined to you.
I believe so, Your Honor, yes. I believe
okay.
So. And I would say that let's address the medicine for a moment, if we could, Your Honor, assuming that Frye is going to apply to the underlying scientific principles, as they say. It is clear in the literature. Okay? See, the other side cites all these cases from out of state, and they call for an exact correlation, an exact cause and effect. That's not the law in Florida. The law in Florida does not require you to have some airtight scientific analysis. You have to have reasonable evidence. In Castillo, the court says that the expert cannot base its opinion upon mere speculation, upon the twilight zone of evidence. That's not what we're talking about here. This is a theory which is the post-traumatic fibromyalgia. Folks that have studied this, there's a strong and repeated correlation. There's even admitted, the other side stipulated that there's an association between the two. There's a plausible and a consistent relationship between trauma and fibromyalgia. The only two studies done, ever, that are epidemiological studies are the Buscaglia study and the Alafea study. And they both show a correlation and an association between fibromyalgia and trauma. These studies are published in peer-reviewed, refereed journals. And in fact, there isn't a study anywhere that shows that there is no association between trauma and fibromyalgia.
Don't each of those studies then qualify their conclusions by saying, while we see a relationship, we can't say it's definitive and a lot more work is done before we can draw that conclusion?
Oh, absolutely, Your Honor. There's no intellectually honest scientist in the world that would ever say he's exhausted all the knowledge. I mean, every study that you read says we need more study, we need more information.
Is there any evidence of the causal relationship?
Yes.
I mean, the fact that they both occur frequently is one thing. The notion that one causes the other is to me what's missing.
Your Honor, at one time we knew that lung cancer and smoking had strong correlation. We did know the exact physiological mechanisms to describe that. And in Florida law, we don't need to know the exact science. We don't need to have a study that shows exactly. All we need to show is that there is a strong association. There has to be reputable, plausible evidence to show an association between the two.
Why?
In fact,
Why does there have to be that?
because that's not the law in Florida.
Well, I thought just pure opinion was sufficient, that we didn't have to have any relation.
That's correct, Your Honor, but I'm assuming now that you're going to apply the Frye test and the alternative to the experts under scientific principles. And what I would argue, essentially, that there's plausible evidence that this is a legitimate thing.
So Mr. Stenberger, if my dog barks about the time the moon rises every night, can an expert come in and say, well, every night about 7 o'clock or so, the dog barks, and lo and behold, the moon comes up. So there is a causal relationship between those two. Is that the sort of expert testimony? You're suggesting that that's enough. The expert, that's his pure opinion. I got an opinion, and that there's a causal relationship between Judge Orfinger's dog barking and the moon coming up.
Your Honor, if experts and litigants are going to proffer specious testimony like that, then that can be exposed, as would any other witness who would lie or would stretch the truth. That can be exposed as a matter of trial. Your Honors, in the record...
Your time's expired.
Let me just ask one other question. One of the other things that bothers me about this is, as you said earlier, it doesn't matter for purposes of medical treatment whether it was caused by the accident or not. In other words, what we're talking about here is we only care about causation from a legal standpoint, not from a medical standpoint.
I believe that's correct.
So why would we allow a physician, for purposes of a legal opinion, to just come in and testify based on nothing, when it's irrelevant to his job?
Your Honor, doctors and experts all the time render opinions as to the cause of a particular condition. That's nothing new and novel. And the fact that the treatment would be no different, I don't think undermines the ability of the expert to render an opinion regarding the causation of a particular condition.
Well, but under those circumstances, we have evidence of what the causal relationship is. Here we do not.
Yes, we do have evidence, Your Honor. It is not airtight, scientific, it is not cause and effect.
It's not cause and effect.
Correct.
It's association.
That's correct, Your Honor. And even they've granted that. And in fact, their own expert, John Rice, in the record.
That's fine.
Counsel,